Hello, my name is Johnstone. I'm the solicitor in charge of the firm, and I've had a number of enquiries recently asking about the risk of imprisonment for a motoring offence. Generally, prison is a last resort for any court, so for the vast majority of people it's unlikely that you'll be sent to prison. Having said that, if the offence is extremely serious, then yes, there is more of a risk of a custodial sentence. Some offences don't attract a prison sentence at all. So speeding, it's a non-imprisonable offence. It's just penalty points or a disqualification. Admittedly, that can be bad enough if you're disqualified, but it's not a prison sentence. So only certain offences would attract a custodial sentence. The main ones being dangerous driving, drug driving and drink driving. So how do you get round this problem? How do you avoid a prison sentence? Well, first of all, it's having a look at what the breath reading or the drug reading is. The drink and drug driving law, by the way, is based pretty much on the same type of law. Drink driving has been around for a long time. Drug driving is a relatively recent development in law, but the drug driving law is built upon the previous drink driving law. So a lot of the principles, a lot of the processes are the same for drink driving as with the drug driving. So the prison sentence comes in if the reading is extremely high. If you have a very high alcohol reading in relation to the limit, and the same way with drugs, then there's a higher risk that you would go to prison, even for a first-time offence. With drink driving, because it's been around a lot longer and it's more established, then we're able to tell from looking at previous cases and from sentencing guidelines, and those guidelines are there on the internet, the likelihood of a custodial sentence if you are convicted. Generally, prison sentence would start at 120 micrograms. So if you reach 120 and the legal limit's 35, the starting point for the court is a custodial sentence. It doesn't automatically mean you go to prison, but that's what the court will consider. And then they look at any aggravating and mitigating factors. 90 micrograms is where probation starts, and you might have a community service order. Of course, that's all in addition to a lengthy disqualification. With drug driving, slightly different because there isn't really any sentencing guidelines as of yet. They've just not been designed. And so looking back on previous cases, it's always a little bit uncertain as to how the court deals with it. And different courts around the country do have a slightly different view as to how they will deal and sentence with somebody for drug driving. But for most people, court, it tends to be cannabis, and the amounts of cannabis tend to be around about 3 times the limit. Now that sounds high, but the limit is only 2 micrograms per litre of blood. It's a very small amount. Now, if you then look at 3 times that, it's only 6 micrograms, and it's a zero tolerance offence. So the limits are set purposely low. So it's a very small amount that can put you over the limit and can put you quite substantially over the limit. So people do have a fear of prison because they might be 3, 4, 5 times the limit, but it's not as bad as the drink driving if you're 3, 4, 5 times the limit. But it depends on how the court views it. And that's really why it's important to take proper legal advice and have representation in court, because you don't want the magistrates or the judge viewing you as 3, 4, 5 times the limit and sentencing you as they would with a drink drive case. At M.A.J. Law, we don't charge for initial legal advice, so please get in touch and we're happy to go through things with you. And if we were acting for you, most of our cases are undertaken on a fixed fee basis to try and keep costs as low as possible for you. But thank you for watching.